ambulance trial, case Ato Forson, who is also the minority leader in Parliament, hopeful of the court ordering a discontinuation of the case against him. Third accused, Richard Jakpa, who has stirred controversy in recent weeks, also was hopeful of injuncting the entire prosecution. But this afternoon, the court has been very busy dealing with the little yet significant issues raised by the parties. First, the Mistrial application has been dismissed by the court. Richard Jakpa's application for injunction was also dismissed by the court. And the Attorney General has been advised to recuse himself from the case following a release of an audio tape in which he is heard coaching the third accused and artificially directing the course of the case. So much has been happening in court today, and we'll take our time to unpack them for you. First, my colleague Latif Idris was, in a courtroom where everything unfolded, and he joins me here in studio. Latif, first, let's talk about the mood. I mean, this is a political issue, so you expect to have political, representatives backing it. So let's start from the mood before we get to the substance of the matters.
Yeah, so the mood, just like the last time we were in court on this same case, the court packed to the brim. You have bigwigs from the opposition NDC, bigwigs within the governing party MPP showing up in court, members of parliament showing up in court, notable lawyers in Ghana showing up in court. Nana B was in court today.
The national organizer of the MPP.
Of the governing MPP. So various interests, involved, all of them showed up in court today. Attentively listened to the ruling. It was a 40-page ruling. And the judge said she didn't have enough time to draft this ruling. And that took her 40 pages. 40 pages. It tells you that if she wanted to go on and on, it would have been, we'll be looking at maybe 100 or 100 and over. So it was tensed because the matter, whether the matter goes in the favor of the accused persons or in favor of the Attorney General, largely hinged on today's ruling by the sitting judge.
And of course, whether or not the substantive case will continue to be heard by the court.
It hinged. Yes. It was on the line today.
Exactly.
And so it was tensed, anxious mood.
Right from the start.
Right from the start, because that was what there was today, just to come and deliver the ruling.
And then set the tone for the future of the case.
Exactly.
Right. So before the judge had made it clear that he was not going to allow oral submission, he was satisfied with the written submissions.
Yeah, that was last week when she made that pronouncement that, okay, I have 4 applications before me. There was an objection. I think I have enough to make a ruling on the application. So I wouldn't allow any oral arguments to precede my ruling today. And that was exactly what happened.
All right, so let's first understand the applications that were before the court.
Okay, so the applications were, one, that the first accused, that is the minority leader of Parliament,
Ato Forson.
He wanted the court to declare mistrial in the sense that the case should not continue. That was his application. Then he filed another application to support Richard Jakpa's application. That sought to say that the case should also end. The allegations or the accusations leveled against Richard Jakpa should be struck out and alternatively be stayed, and then he be cross-examined based on the tape they sought to tender into evidence. In all, there were 4 of them.
Including affidavit in opposition by the Attorney General.
Exactly. So those were the 4 applications before the judge, and she delivered the ruling on each and every one of them in detail, referencing both local and international precedents to back the decision she made today.
So let's take them one after the other. So the first issue was about an application for a mistrial.
Yeah.
Tell me the decision of the court.
So I just want to quote what the judge said here, and it's very short. He said, I shall decline the invitation to declare a mistrial.
Did she provide reason for this decision that she's taken?
So a quick one, this tape, this Jakpa tape, came out some 2 weeks ago.
Almost.
Yeah, two weeks, let's say about 2 weeks ago. This case, the substantive case, we all know, has gone on for the past 2 years. Been in court, filing, arguing, here and there. The position of the judge delivering this ruling is that how can an evidence which has just surfaced 2 weeks ago come to derail all the hard work that has been done by counsel for the first accused, counsel for the second accused, the attorney general, and then counsel for the third accused? How possible, in the sense of the judge, should a 2-week-old audio recording come to derail time,
the process,
resources, everything that has been dedicated to this trial for the past 2 years? To her, she finds it unacceptable to declare mistrial. Also referencing the fact that in Ghana, the term mistrial is even alien in Ghana's jurisdiction. She couldn't find any law in her ruling. She couldn't find any law to back the call by Dr. Ato Forson for a mistrial in this case.
Therefore, that application was misplaced.
Yeah, so she dismissed. You know, we can go on giving the reasons why she declared it dismissed, why she dismissed the application for mistrial. But like I said, it was a 40-page ruling, and we could not grasp all the quoting she made from Canada and the United States. But the bottom line is that this audio recording is just 2 weeks old, and there is no way a 2-week-old audio would derail a 2-year investigation and the trial that has gone on since then. And then
the other issues also had to do with the conduct of the Attorney General in all of this, to the extent that an application was seeking the leave of the court to make pronouncement on the conduct of the Attorney General, and the fact that the claim is that he was involved in witness tampering, if you like. Yeah. What was the decision of the court?
So the judge said she has listened to the audio recording 10 times since they tendered it in, 10 times. And in nowhere in the audio recording, according to the judge, did she hear the Attorney General, Godfred Yeboah-Damin, say to Richard Jakpa that I want you to say X, Y, Z to implicate Ato Forson, and that you are not my focus. It is Dr. Ato Forson who is the focus. So say X, Y, Z to implicate him. The judge said, after listening to the tape for 10 times, there was nowhere in the audio recording that points to the assertions made by Richard Jakpa that the Attorney General sought to manufacture or interfere with the evidence before the court. Now, she said, Richard Jakpa said in the audio that he was going through ordeal. According to the judge, those words were never uttered by Godfred Yeboah-Damin. It was Richard Jakpa who made those declarations. Again, Godfred Yeboah-Damin, the only thing he said, according to the judge after listening to the tape, is that I am not asking you to help me. The only problem the sitting judge had with the conversation in her ruling is where the Attorney General is allegedly heard advising Richard Jakpa to go to a hospital and secure a medical excuse document to present to the court to delay the proceedings so that he could travel, return, and still meet Jakpa in the witness box. That the judge found a bit problematic. And so she advised the Attorney General that if he would take her advice, he should step away or recuse himself.
She didn't direct. She didn't order. She only advised.
It wasn't
subject to the rejection or acceptance by the Attorney General.
Correct. It was an advice. It wasn't an order or a directive. It was an advice. And in the proceedings, even after the advice, giving us a clue as to whether or not Godfred Yeboah-Dame would take the advice or
reject
otherwise, he went on doing the case.
After
advice,
dealing with these applications.
Yeah, he went on doing the case.
Suggesting that he's yet to consider the advice by the judge.
Yeah. He went on and did the case, asked questions, wanted clarity, wanted direction, objected to, some of the things that later came up, when Richard Jakpa was put in the witness box. I'm sure we'll come back to that later on. So we do not know whether or not the Attorney General would continue to do the case, or he will take the advice of the judge and then recuse himself. That is his discretion. He has that decision to make.
But then also there's a matter where the judge says that in terms of the alleged misconduct of the Attorney General, it's not a matter that the court can pronounce a decision on. That can best be taken by the General Legal Counsel.
Exactly. So that's what she said. She said it is not within her jurisdiction to make a pronouncement or a ruling on that. And so the only institution that is clothed with the powers to deal with the matter is the General Legal Counsel. So as to whether or not Mr. Jakpa would take this up with his lawyers, or the NDC would want to do that and go to the General Legal Counsel, which they've already given us indication of doing.
That they will take it up.
That they will go to SHRAJ, they will go to the General Legal, they will trigger everything that is readily available and legally allowed for them to do. So they've already given us that indication that they will leave no stone unturned to make sure that Godfred Yeboah-Dame does not remain in the seat as the Attorney General of this country.
No, the tape in question, the recording, that formed the basis of these applications that eventually almost all of them rejected, if you like, by the court. So my understanding is that it was tendered in as evidence and accepted by the court.
Yeah. So you find. Well, let me be careful in my words. So let's just discuss what happened. So the judge in her ruling says that I have listened to the audio 10 times. And I didn't find any incriminating phrases, comments from the Attorney General, apart from the medical excuse duty form that she made. But then she also says that I have admitted the audio into evidence. And so that is about it.
So therefore, as far as the substantive matter is concerned, is it your understanding that the audio recording may be part of the evidence the judge will consider in arriving at the decision on the case of willful causing financial loss to the state against the minority leader?
Well, so she also talked about weight, the weight she would put on the audio evidence. Okay. So the weight, we don't know whether she's going to put 10 pounds or 1 pound on it. We don't know. But in her ruling, she mentioned weight, whether the weight will be strong enough to make the case for Ato Forson and Jakpa, or it will be too weak so that the Attorney General will have his way. We do not know the weight she's going to put on the weight. But considering the fact that she said she's listened to it 10 times and didn't find anything to incriminate the Attorney General, and the fact that the only thing she found problematic was the medical excuse duty, and that she doesn't have the jurisdiction.
And that the General Legal Counsel should look into this matter.
So you want to...
So Latif, I'm interested in the reaction from both sides after the court cleared these applications.
Yeah, so I spoke with Attorney General, and the first question I asked him was, you've been advised by the court or by the sitting judge to recuse yourself from the ongoing trial.
Yes.
What do you make of it?
What was his reaction?
His reaction was exactly what we saw in court. He said, well, you saw me. Even after the advice, what happened in court?
I went ahead to work
to do the case. So Then he referenced what he told us, and I don't know if that tape is ready that we could listen to, but he was singing.
We don't have it yet, but we're working on it. We'll bring it to our viewers before we end the show today. It's very important that we hear from the Attorney General after the court ruling. The court advised that he should recuse himself from the case and what he intends doing. And you are telling us that even after that advice, he went ahead to cross-examine Richard Jakpa.
Not cross-examine yet. So for now, I'm sure we'll come to Richard Jakpa being in the box. So he made the point that you saw me even after the advice by the judge, I still went ahead to do the case, given the inclination that he will humbly or respectfully turn down the advice. He didn't say that explicitly.
Right.
We do not know, but that's what he said. That you saw me that even.
We'll hear from him shortly.
Okay.
So what happened after the applications were dealt with, as far as the substantive case is concerned?
Yeah, so after clearing all the applications and dismissing same, Richard Jakpa was called into the witness box to be cross-examined by lawyers for Dr. Ato Forson. And so Eduji Tamakulo represented Aziz Bamba, who couldn't show up in court today. He's the lead counsel for Dr. Ato Forson. So the audio tape, despite the ruling of the sitting judge, Richard Jakpa's team are still holding dear to the audio tape. So he asked Richard Jakpa if he had something he wanted to bring to the court. And he said, yes, I have the audio recording on a pen drive in my bag. So the judge gave him the permission to go and pull it from his bag. He went, pulled it, brought it. Then Eduji wanted, I don't know if he wanted him to say to the court he wanted to play it or what. But in the middle of his cross-examination, I think Thaddeus stood up and said, they want to have a look and examine that evidence. You never know.
Sorry, here is a lawyer for Richard Jakpa.
Jakpa, yes. So he was now speaking for his client. That Eduji cannot just say that he should just tender it in. He wants to assess the audio recording, the pen drive, and make sure that it is indeed what his client would like to tender into evidence.
All right.
So now, the Attorney General, Godfrey Yeboadame, also stood up and raised some objections to that effect, which was overruled by the sitting judge. And so, long and short, that audio recording was allowed, and Richard Jakpa, according to the sitting judge, has asked that they should file it. So now, when it's filed, he will be cross-examined based on the content of that audio recording. The understanding we are getting, or we got after the proceedings with Sami Jemfe, is that this is the beginning of the flow of other audios. And that the strategy is going to be that they are now going, during cross-examination, we will get Richard Jakpa to be turning in additional audio recordings, if any, between him and then the Attorney General, Godfrey Yeboadame. So this went on, the cross-examination went on for like 5 minutes, and then the judge said, okay, enough. We are going to adjourn it to Tuesday at 11 when the court will reconvene. The AG would have 5 hours. Eduji Tamakulo will have 4 hours.
For what exactly?
For the cross-examination.
Of Richard Jakpa.
But what is unclear is whether it's going to be just for Richard Jakpa.
Because I do understand that as far as the first accused is concerned, they have closed their case.
Closed. Yeah, so it's going to be Richard.
The prosecution almost has closed his case.
Yeah.
So what is left is Richard Jakpa.
Richard Jakpa. So it's going to be Richard Jakpa, 5 hours for AG. Eduji Tamakulo will have 4 hours. And then on and on we go.
All right. So Latif, I'll let you hold on for now. So you heard Latif Idris. He was in court today telling us what transpired in court today. The decision of the court on the applications that were before the court, and then as far as the substantive case is concerned. Now, the Attorney General, Godfrey Yeboadame, has been advised by the court to recuse himself from the ongoing case. Is he going to do that? He spoke to my colleague, Latif Idris, after the hearing today. We can take a listen to what he told him after.
What do you make of the ruling? First off, let's begin with the directive by the judge who advised you to recuse yourself from the ongoing.
Please, stop this sensationalism. I think you remember you were in court. The judge herself, even after the ruling, clarified that she has not given any such order at all, and that is only an advice. Yes. And what did you notice afterwards? I'm conducting the matter. I'm still conducting the trial. The most important point today is that all the applications filed by the applicants have been dismissed in their entirety. All the 5 applications have failed. And I think that in reaction to this, I would say that clearly shows there's a group of people in this country who ride on manipulation of facts, distortion, and deception of the public. They're always seeking to mislead and deceive the public. Today they've been exposed. That is what I say. I leave the rest to my friends.
So now that they've been dismissed, all the applications have been dismissed. Yes. How do you see this case going forward?
Well, today, when I was coming, I had a song in my spirit. Head of the church triumphant. You know that song? Please. We joyfully adore thee. And then it goes on. Precisely. Continue. You have to play it in your radio stations. Head of thy church triumphant, we joyfully adore thee. And I said to you that they will lay traps, but all the traps I'll flee from them. And indeed, only righteousness will prevail.
Would you object? Would you object to the audio record now available?
I'm not speaking again.
What about the specific finding? The specific finding. The specific finding that in the engagement you didn't make any specific comment.
I think for me that's again. Oh, please stop. Okay, I think that's also the. You see, that for me epitomizes the deception of the public I talk about. I speak about the deception, distortion of fact, and manipulation of the public by a group of people in this country. You heard the judge say today that 10 times she had listened to the audio. She never heard the attorney general utter those words. And those words, if at all, came from the mouth of Richard Jakpa.
Thank you very much. So that's the Attorney General, Godfrey Yeboah-Darming, who was just, he sang a song I don't know, just to indicate that he is going to prevail. Just referencing what he said to us the last time he was in court, that they're going to set traps on his way, but he will prevail. He's referenced that today. And what the takeaway from the court today is the fact that the court has dismissed all the applications filed by A3 and A1, that is Dr. Ato Forson and Richard Jakpa. Now the applications have been cleared. We will try and get some representation from the NDC camp who were in court to show solidarity to. But let's begin with Nana B was also in court. A quick one from Nana B. What do you make of the proceedings today? Dismissal of all the applications by A3 and A1. And what is also another takeaway is the fact that the AG has been advised to stay away. Let's begin with the dismissals.
I think, first of all, this is what we've been saying all this while, that you cannot churn falsehood outside in the public domain, and you think you can transfer such falsehood into the courtroom. No, I mean, I've always said this, and today they have been exposed badly, right? And all the applications they filed were dismissed, and we were all in court. The judge gave, reasons, deep reasons, well researched reasons why all of these applications were must be dismissed, right? So first, you notice that they said that the court should compel the AG to discontinue the prosecution. It was dismissed. They also mentioned about the fact that they filed a motion for mistrial, again, was dismissed. And even the court, the judge in court today said that she listened to the tapes 10 times, and nowhere on the tape were statements like implicate Ato Forson, coaching the accused. No, never. But this is what were being played outside. I mean, people playing to the gallery. The court said that it listened to the tape 10 times and nothing of that sort. And
you also agree that she finds it problematic that the Attorney General was engaging a suspect or an accused person in a conversation on a matter that is sitting before the court?
I'm not sure she said.
She said that.
No, she said that.
That is why she advised him to stay away.
Anything at all, there should be a different platform for that, and that is why she suggested that it is General Legal Counsel, right? And then she said that because of public interest and how this matter has generated, so much public interest, she will advise. Indeed, if you recall in court when the Attorney General stood up to speak, she again repeated that advice. That is only an advice, right? So anybody who will come out yesterday that the Attorney General is ordered not to be part of the conduct of this matter is clear falsehood. And I know people will start trying to push that out. She said advice.
So that's the national organizer of the ruling MPP, Henry Nana Boakye. Let me bring in private legal practitioner Kweku Pentel, who joins us via Zoom. Mr. Pentel, it's a pleasure to have you here on the Pulse. Good afternoon. So, Counsel, if you can unmute for me, and good afternoon, welcome to the Pulse. I think we need to fix that audio with Mr. Kweku Pentel, and then we can have him. Yes, so, Counsel, good afternoon, welcome to the Pulse.
Good afternoon.
All right, so just 1 second for me. My legal affairs correspondent is wrapping up. So, Latif, the next hearing will be what, on Tuesday?
Yeah, on Tuesday at 11, same court. So we might hear the audio tape played in court now that it's been admitted in court. We've gone through the process.
The judge has already heard it 10 times.
10 times.
Anyway, so we'll put that question to those who have knowledge in this area. And Mr. Kweku Pentel, you followed the ruling.
Hi.
So you followed the ruling of the judge in this case, the applications, and of course, virtually dismissing all of them. The other one relating to the conduct of the Attorney General, she advised that he should recuse himself from the ongoing trial. First, your initial reaction to the matters that the judge brought finality to it, the applications.
Yeah. So what's your question? Some disruption came from my side.
All right.
So let me know what's the question.
So first, perhaps we can start from the judge directive or advice to the Attorney General that in view of how perhaps I'm restraining myself from using certain words that were not used in court, but the Attorney General has been advised to recuse himself from the case, basically because of certain comments that the judge highlighted in this telephone conversation with Richard Jakpa. I mean, the advice, is subject to the acceptance or rejection by the Attorney General. But what do you make of it?
Well, like you yourself have said, an advice is an advice. You can take it or leave it. And personally, I don't personally, with due respect, see any real justification for the Attorney General to recuse himself from the case. The specific allegation that they made against him have been, at least for now, as a basis for curtailing the trial, has been refused by the judge. And therefore, that is so. I'm not too sure that it's going to have any impact or any effect or any bearing on a substantive trial, whether indeed the Attorney General did anything, which is untoward. I've already expressed a view about last week thereabout, that if even there is any such allegation which can be proven, it does not go to the substance of the matter before the judge. It's an issue of the conduct of the Attorney General, which may be tried in a different forum. That is to say, if their argument is that the conduct of the Attorney General in any circumstances is untoward or it's not, it's not right. It does not affect the substance of the case before the court. And that's why I don't think that the Attorney General can even be advised. If the judge has sufficient reason, she has enough powers on authority to recuse the Attorney General if she's got sufficient reason. But this advice, fair enough. I don't honestly believe that the Attorney General is obliged at all to accept an advice from a certain judge. I'm not sure. So that's the way it goes. If the Attorney General decides to go ahead, yes.
But if I should allow you to read the judge's mind, why didn't she go ahead and say that I'm directing you to stay away from the case, but rather use a word that provided a window of opportunity for the Attorney General?
That is the riddle. I mean, if the judge had sufficient reason, the judges act on the basis of evidence that they have before them. So if the judge has sufficient reason, not reason, but the evidence, then she will have good reason. As we speak now, the judge does not have sufficient reason, and I believe that if in the course of this trial, the judge has got good reason based on good evidence that she must recuse the judge, recuse the Attorney General. She's got the power to do it. For now, she doesn't have the power to do it, and that's why she advised. As to why she advised, fair enough. She's a judge. She's entitled to. But like I said, the Attorney General is not obliged at all, one way or the other, to accept the advice. So I agree with the Attorney General if he believes he wants to go ahead with the prosecution. The way forward is his.
But Pinto, regardless of that, for the judge to come to the decision that the Attorney General should advise himself whether to continue or not to continue, that is that dent his image. I mean, clearly, it tells you that perhaps the judge feels that the way you've conducted yourself doesn't put you in the right position to continue to prosecute this case.
No, the thing about a court is that not only of observation, but the power to make orders, consequent upon findings. If the judge has sufficient reason, nothing will stop her. The advice that she given to the Attorney General, an advice is an advice. An advice is one for taking or rejecting. And like I'm saying, if at any point in time the judge has enough evidence to show why the Attorney General must not continue the prosecution, she will be bound to make an order to that effect. And I'm also not too sure that there is any evidence before the court now, which of course, if subsequently it comes out, can impair the trial of this matter or can in any way affect the outcome of this matter. Those are the only circumstances that possibly an order will be made or an advice will be made to the Attorney General. So far, I myself follow this case a little, and I've expressed opinions on this matter, including those that I expressed last week. And I could just have told you that we're going to come to this conclusion, which is that the applications that were filed to recuse Attorney General or to terminate the trial of the criminal cases were going to be thrown out of court. And that's what exactly has happened. We give judges respect, but the judge has restrained herself, suggesting that as things are now, she does not have sufficient legal justification for recusing the Attorney General. So let it stand as that. We thank her for the advice, but let her advice to the Attorney General stand as an advice. An advice is for the taking or for the rejection. And if the Attorney General has opted to give the judge the maximum respect by refusing advice, he is within his rights, and that is it. At the end of the day, this case will be tried on the basis of the evidence that will come before the court, not on speculations, not on any way anybody thinks about any matter that does not happen in the court. And please take this from me, that it's not every evidence that comes before the court that's got a bearing even on the determination of the issues before the court. Some evidence may just be scandalous. Some evidence may just be to whatever. But I'm just making the point that even if it is true that the Attorney General, as they say, even did what they claim he's doing or has done, that will not, in my honest view, affect the trial, the substantive matter before the court, which is whether or not the accused person did what the prosecution said they did. It's as simple as that.
Right.
That's why the judge has admitted. Yes.
Yeah. So, Counsel, this is the Attorney General, leader of the bar, an officer of the court, standing in the very court, he said on tape, advising a witness to, if you like, mislead the court by going to take an excuse duty. On what moral grounds will you appear before the same court and then be making certain demands?
Please, the judge has not made a finding of fact. Don't forget that at this stage, they are mere allegations. Let us all bear that in mind. Nothing has been proved before the court suggesting that the Attorney General has done anything untoward. possibly, if I look at what the judge said, the worst interpretation that you can give to the to what the judge said is that there's a possibility that maybe based on what she's hearing, things may come to the point where some findings of that sort may be made. But as things are now, the judge has seen nothing that compels her to order the Attorney General to, terminate his conduct of the brief. And with due respect, an advice is an advice. And therefore, I would suggest that the matter will stand at this point where it is, and the Attorney General will choose to accept or ignore the advice. As things are now, he has chosen clearly to ignore the advice. There is nothing that suggests, as we speak now, that he has done anything untoward. Right. But what happens is that there are clear allegations which the defense try to rely upon as a basis for having the action dismissed. The judge has weighed the evidence as they stand now, has come to the conclusion that after listening 10 times to this allegation or the statement that the Attorney General is alleged to have made, she has come to the conclusion that so far that evidence is not borne out by what is before the court. She has also done well by admitting everything that they claim the Attorney General said, both in writing and, of course, also by the audio evidence. And the court will weigh all of that as part of the evidence, the total evidence that will come before the court, and consider whether in the light of the evidence in support of the substantive allegations about or concerning the defense, or rather the accused persons, the judge will have to determine whether if those allegations have been proved, and if they are proved, whether by reason of anything that Attorney General is alleged to have said, concerning the matter in court, whether that can bring the evidence down. In other words, whether that would inure to the benefit of the accused persons. I have said it about last week I expressed a clear opinion that we are dealing with two separate matters, one related to the conduct of the Attorney General. If you've got the evidence, you know where to go. But as far as the trial of the matter is concerned, the prima facie evidence has clearly been established. In other words, at the point at which the judge will invite the defense to open their case, we've gone beyond what we call establishing prima facie evidence. That is to say, evidence that is weighty enough to compel the court to go to a trial. All that the defense team has to do is to ensure that they are able to discharge the burden of demonstrating that the evidence or the prima facie evidence does not carry weight.
Right. Thank you so much.
That's my view of the matter.
Thank you so much. Thank you so much. And